So Marina, please,
Thank you, Carolina.
your place.
And hello, my name is Marina, and I am a first-year PhD student here at the University of Helsinki and a member of the Anywhere Research Project. I was supposed to give a presentation yesterday at the Hyde Park session, but we had an unfortunate change of plans because the last panelist of this session couldn't make to Helsinki, so I gladly offer to fulfill this spot because I was having a hard time keeping my presentation to 5 minutes. I'm excited to share some of the developments, some recent developments we've had with our constitutional animal protection provision in Brazil. So, but before, what I am seeking to do with my doctoral research is to provide a sort of overall framework on constitutional animal provisions, and I'm putting in a particular emphasis on the Brazilian experience for reasons that I will go back to in a minute. I think Vera, where is she? She touched in this, so I won't extend too much on this part, but just to provide some background. So the problem where my first questions arose, so to speak, is that this imbalance where we have the most important interests of human beings protected by fundamental rights, which are usually included in constitutions. So, for instance, the right of property, the freedom of religion, freedom of occupation. In Brazil, it's very often referred to this cultural rights to cultural manifestation. And on the other hand, we have the interests of animals protected in animal welfare statutes, and that's the situation for most Western jurisdictions. And as a result of that, animals enter in the dispute in a very disadvantaged position, and their interests are very often easily overridden by human interests. However, some countries do already protect animals in their constitutions, and this is a list that is growing fast. It was supposed to be 8 countries, and now we are already in 11 with the most recent addition of Italy. And just to clarify, when I refer to animal protection in the Constitution, I am talking about some kind of declaration of concern with individual animals, so it's not mere references to animal husbandry or anything like that. So what I'm trying to investigate is whether this added constitutional weight is effective in increasing the protection of animals in the welfarist paradigm. And I chose the Brazilian experience as a case study for some reasons other than the fact that I'm Brazilian myself, so I have an easier access to some important resources like Portuguese case law databases, but first because it's not very known internationally. And I have recently read some interesting comments and interpretations of what's happening there in Portuguese, and I have been noticing this kind of unconformity between what's commented by international animal law scholars and what's been said in our Brazilian literature. So what I'm trying to do is kind of bridge this gap and provide a coherent analysis of what is this article and its developments. And also, the provision is in force for over 3 decades now, which provides for a substantial number of case law that I can work with, which is useful for longer projects like PhDs. And last, but probably most importantly, because it's the only one, as far as I am aware, among that list that has that the provision has direct applicability in an accompanying broad-standing regime. So, in a nutshell, we have some mechanisms in place to represent animals and invoke this provision before the courts, and I will go back to that in a minute because I think it's important. But before, just to present the provision, that's the text. So I don't think I need to go through every line, but just the most important part. So it starts in a very anthropocentric way, saying that everyone has the right to an ecologically balanced environment. And to ensure the effectiveness of this right, it is incumbent upon the public power to protect the fauna and flora, prohibited practices that jeopardize their ecological function, cause the extinction of species, or subject animals to cruelty. So I think a remark is that this final part that I highlighted in bold is what makes all the difference, and the responsible words for everything that I will comment in the next slides. So in a way, it resembles the German state objective in the sense that just the addition of a few words caused all the gist. So, and there is the question of the legal nature. What is the precise legal nature of this provision? And this is another factor of unconformity. Like, for instance, Jessica Eisen and Yannick Evink refer to it as a state objective, and as far as I am in my research, it's my opinion too. I think I agree with them. Then Olivier Lebeau mentions it, describes it as a ban in the sense that it prohibits the cruelty to animals, and then most Brazilian scholars refer to it as a fundamental right. The majority of them say it's a third generational fundamental right of human beings, similarly to environmental rights, and there is a minority there that says that it's interpreted in a way that confers fundamental rights to animals, which is quite intriguing in my view. But curiously, this is the view of most adopted by the Supreme Court. So going back to the matter of legal representation, so we have these two mechanisms in place in Brazil that have been used to invoke this right. So first, the judicial review proceeding that is regulated by the Constitution itself, and this is the list of actors that are enabled to initiate proceedings, and this is used to deem any ordinary law unconstitutional if it contradicts the constitutional ideology, and it's a lot, so I think we can focus for the scope of this presentation only in this parts that I highlighted. So on this side, we have national class entities, and for instance, I am a part of the Association of Animal Lawyers in Brazil, and as long as you are a national entity with any kind of class entity with national scope, you are already fitting the criteria to use this to bring a case to the Supreme Court. So this has been used in most of the cases that I will comment later on. And we also have this, it's hard to come up with proper translations, but like the literal translation of this kind of mechanism would be public legal lawsuit that is used, for instance, to try to come up with civil compensation, so different kind of lawsuits. And among the actors that can use these mechanisms, associations that have been constituted for at least 1 year and that have among its institutional purposes the protection of, among other things, the environment, curiously. And this has been sufficient to enable animal protection organizations, for instance, to use this mechanism. So some examples. We have many, I wish I had time to talk about other ones. We had the wild parrot case that has been cited a lot, but I unfortunately did not include it in my slides. But there's this Vaquejada case from 2017, for example. Vaquejada is one of those examples of very weird cultural manifestation events involving bulls and cows and oxen, like in the family of touradas and rodeos. And what happened is that one tiny state in the Northeast had a state law regulating the activity, and then there was this proceeding trying to deem it unconstitutional because it was a law against the constitutional provision, and the Supreme Court decided that the law was indeed unconstitutional and the activity should be prohibited. And as you can see, very progressive language used by the ministers, like saying, recognizing animal dignity and things of that sort. And I think this is where most of the mentions in international literature stop. Like what's usually mentioned are these public spectacles involving animal cruelty, but I wanted to include other examples to say that the effects go beyond that. So there have been some cases. I heard of two more after I have finished with my slides, but some state law in, for instance, laws from Rio and Amazonas prohibiting animal testing for cosmetic and cleaning products. And these laws have been challenged by the pharmaceutical industry. And after all, the Supreme Court decided that the prohibitions should be upheld on the basis of this constitutional provision. So other kinds of developments. And beyond the Supreme Court, so we recently had this very interesting case, the Rumble and Spike case. So basically, 2 dogs were left alone at home, and the owners traveled for a month. And the neighbors started to hear the dogs barking and crying and try to throw some food over the wall. And at some point, an animal shelter rescued the animals, and they initiated a lawsuit against the owners, claiming for financial compensation on behalf of the animals. And because they lacked legal capacity to act on behalf of the animals, they put the 2 dogs as the plaintiffs. And the lawsuit was dismissed in the first instance, but then in the Court of Appeal, it was surprisingly unanimously decided that the dogs had legal capacity to figure as plaintiffs. So the decision was reformed, and now the lawsuit is ongoing and is waiting for the appreciation of the material law. And this was very recent and the first case in which dogs had legal capacity to figure as plaintiffs. So we are expecting more cases like that to develop in the near future. Other examples include these local codes of animal welfare, like this from the state of Paraíba. We had other examples in municipalities that I've came across, using this kind of very progressive language, again, for instance, recognizing all animals, vertebrate and invertebrate, as sentient and deserving of a dignified existence. But then there is always the question of how far this can go in terms of practical effects and impacts. I've come across some municipal codes like that, very limited in geographic scope, going a little bit further, like saying that the executive power, so like the mayor should do should implement incremental changes as far as possible to safeguard this goal of protecting animals. And in other instances, traction vehicles using animals were also prohibited locally on the basis of the constitutional provision. So my conclusions, and still a work in progress because I'm just starting my research, is that yes, I believe that this added constitutional weight offers a relevant leverage tool for animals in the current system, but probably more importantly than only the legal nature of the provision, which is very important, but also because of all these mechanisms in place of legal representation that make it possible for some changes to actually happen beyond the symbolic effect. So among the other effects, because it provides a legal basis for limiting human rights, such as these rights in the case of cultural manifestations and things of that sort. Also because it commits the government in all 3 branches in a legally binding way, although it doesn't necessarily assign rights to citizens, but in the case of Brazil it does. Not citizens, I mean organizations, specific organizations. And it helps gradually steering the law into a more zoocentric direction. And in a nutshell, I believe that animal welfare law without this constitutional backing can go only so far as the harmful practice on the other side is not protected by an individual's constitutional rights. So that's why I believe it's a positive thing. I don't have a thank you slide, but thank you very much for your attention.